I was rather unwisely, just before the short adjournment, set off to look at the 2+10 document.
Yes.
If I could just finish that for you,
Yes.
if I may. We were looking at it in the supplemental bundle subject 2265.
Yes. We got to 2267.
Yep.
Yep.
That is the most important page identifying the forecast outcomes. But it's important just to get a flavour of the rest of it, because you can see the detailed work that goes into it. One goes over to 2268. We have a waterfall that identifies where savings are to be made.
Yes.
And if one goes over the page, we've got overheads.
Yes.
2269. Again, phase summary, very detailed, month by month. Then we have 2270, specifically estate rationalisation. We've had to redact references to 4 of the
Yes.
facilities to be shut. Then exceptional costs, 2271. And one would appreciate, it's worth just saying there are 3 types of costs essentially involved in this. There's exceptional costs which involve redundancy and so on. There are capital investment costs which speak for themselves, and then of course there's just the cost of bearing the losses in the meantime. They're very separate things. This is of course concerned with all 3 because it has to identify the additional funding required. And then at 2272, we've got the cash flow month by month. And as Moylan then pointed out, there are then many further pages in between, but that gives the court and gave the court more than enough to understand the detail and care which went into that. Now, my learned friend picked up on the July figure. If one goes back to
Yes.
the key page,
Yes.
2267, and says, aha, you're supposed to be, according to this, break even by July. You're not. Mr. McCourt, in the second witness statement, explained that for July it's anticipated a loss of 3.3 million. There's a short explanation for that. It doesn't in any way undermine the reliability of this. There was, of course, a month's delay in this reorganisation, not, of course, anticipated in the 2+10 document, because between the 15th of May, the first hearing of the injunction application, and the 11th of June, the Deputy Judge's judgment, we gave undertakings not to carry on. So we were forced to be a month behind. And of course, Mr. McCourt has particularly referred to the July figure because that is the best snapshot there is of the current situation. So if there were an injunction now, the performance in July is the best facsimile for the likely performance over the coming months if an injunction were granted until an outcome of the trial. So that's why he's focused on that particular month. The other point to make in relation to the reliability of this, not only is this extremely careful preparation of a plan, as you'd expect from a listed company which is going to have to put tens of millions into this process, this is also something that InPost has done before. In Mr. Cushell's first statement of paragraph 9, we don't need to turn it up, he refers to the fact that in 2024, InPost acquired a similar logistics company called Menzies and went through a similar reorganisation involving integration, which was enormously successful. So InPost has done it before. They know what they're doing. Now, that was a bit of a digression, as I mentioned, because of course we say none of that really matters because the loss that we've identified relative to the cross-undertaking is loss that doesn't depend on the success or otherwise of the plan. But if my lords disagree with me on that, then the plan is reliable. And if forced to come to a view, the expectation is that something akin to what's forecast in the 2+10 document is what is likely to be achieved. As I say, a bit of a digression. There are 2 other species of loss, if I can put it like that, in addition to the loss-making trading over the delay period, which is the 33 million, as we've also identified in the scouting argument. Second, there is a potential loss of customers, and we're going back to the position as at June this year now, as a result of the delay. Again, not dependent on the prospects for successful reorganisation. As explained in the evidence, this is just from my Lord's note, McCourt 1, paragraph 44, and that's pages 34 to 35 of the core supplemental bundle, and also Cushel 1, 35.
Sorry, Mr. McCourt, which paragraph?
Sorry, I apologise, going too fast. McCourt 1, paragraph 44.
Yeah.
And I've managed to catch up with the references in the core supplemental bundle now, so that's pages 34 to 35 of that bundle. And then Cushel 1, paragraphs 34 to 38, and that's pages 60 to 63. Mr. Cushel's explaining there the process with new and existing customers at that point, essentially trying to convince them that the problems in peak 2024, which the Yodel business suffered, won't be reproduced in 2025. And what Mr. McCourt does is explain really the ramifications if in fact a large customer were to leave. Now, what is explained is that in fact there are quite a few large existing customers, including 4 of around 40% in total of revenue. So what Mr. McCourt explains is, well, if one of those large customers representing about 10% of the revenue were to leave, if an injunction were granted stopping the reorganisation, then most of that would go straight to the bottom line, because this is a business where there are large overheads, and the loss of revenue doesn't necessarily save that much money. He estimated that there would be some savings, but a loss of one customer accounting for 10% of the revenue would cause additional loss of between 18 and 20 million. Now that isn't inevitable loss in the way that the 33 million caused by loss making over the delay period would have been inevitable. But there was clearly a very real risk that customers might leave if the reorganisation process were halted. And so in fact that 33 million could, if one customer were to have left from the perspective of June 2025, have resulted in perhaps total loss of up to 50 million. And then third, of course, there is the risk of catastrophe administration, which I referred to briefly in response to my Lord Justice Nail's question before the short adjournment. I mean, there, of course, that's again a risk rather than an inevitability. It is more difficult to, of course, estimate the quantum of harm in relation to Yodel. But what one can say is there clearly would be harm to Yodel because of the fact that the business of Yodel would be sold on a forced sale basis in administration, and that would inevitably be less valuable than a sale of the business on a going concern basis. No one's proposing that, but that's how you measure the loss. In addition, of course, that would involve unquantifiable harm to the limited company's employees, potentially, if the business actually failed completely, and a very large crystallisation of loss to creditors. And of course, creditors are the primary stakeholders here, because this company has been balance sheet insolvent for a very long time. Now, just looking at the statutory accounts, we don't need to look at it, but it's one looks at the balance sheet in the last statutory accounts, which is page 2657 in the supplemental bundle, one can see net liabilities of £257 million, with creditors of in total 327 million.
Sorry, where did I find that?
That's in the fifth file of the supplemental bundle, 2657.
Yeah.
So if one looks at 265.7, it's the balance sheet for the company, Yodel.
I look at the
Oh, sorry, I'm sorry. I'm doing what I always do, turning numbers around. 2675.
Yeah.
2675, I apologise. That's the balance sheet. And you'll see total equity towards the bottom, 257 million.
Yes.
So that's the net liabilities. And if one can see also total creditors, we've got total current liabilities of 190 million.
Sorry, hold on. Yes, I see.
And then total non-current liabilities a few lines down, 137. Now this is 31 December 2023. It's the most recent statutory accounts laws, but of course we know that it's been loss-making since, so it's not got any better. So the point is there is a large balance sheet insolvency, and there is a large volume of creditors by value who are going to suffer hugely if the company goes into administration. So those are the three types of loss. Now, of course, that position has now been updated in the evidence of Mr. Cushing's second witness statement and the court's second witness statement, which I take it my lords are content to admit into evidence.
Well, I think it wasn't disputed.
No, it's not, my lord.
Yes.
Thank you. So here, the same three broad categories of the palm still exist, but in a slightly different form because things have moved on. I'll explain that if I can quickly. There is still inevitable loss through loss-making trading, but for a shorter period, of course, if an injunction were to be granted now, and at a lower burn rate. We've seen the burn rate, that's the 3.3 million, which is the estimated July loss figure. So that's the best figure we can get for estimating what the loss would be over the coming months if the process was frozen by an injunction. Because, of course, steps have been taken, the organisation has moved, therefore some of the loss making has been ameliorated, reduced, but not completely. Now, one also has a delay period not of 6 to 7 months now, but 4 to 5 months. Again, I would anticipate a delay of restarting the reorganisation, if that's what happened, until January 2026. So if one looks at a 5-month delay, 3.3 million per month, we're looking at 16.5 million. So it's not 33 now, it's 16.5. But it's of the same nature. Then the second category of loss that I referred to just now, that is potential loss of customers, that has changed significantly because the threat of loss of customers is actually greater, and it's more of a threat to the viability of the business. Because what you have seen from Mr. Cushing's second statement is that some big customers have now agreed, in principle at least, that they will use the Yodel in-post service over peak 2025, which is what Mr. Cushing explained he was going to try to achieve, and now to some extent he has. But what that does is to pose a serious risk, because what he's identified, in particular, 5 large customers. TVG, the very group, is the one that's identified by name, to which my learned friend referred. That is one. There are 4 others that he refers to. This is in paragraphs 12 to 20 of Cushing 2, and that's pages 134 to 136 in the core section of the bundle.
Yes.
I don't want to take my lord's right now, you've seen it. What it amounts to is an anticipated peak volume from those 5 customers alone of 25 million parcels during the peak period, and that amounts to revenue of 40 to 50 million. And one sees that from paragraph 10 of Cushing 2, that estimate, which is at page 133 of the report.
Yes.
And the concern, of course, is that if an injunction were granted stopping the reorganisation in its tracks, then those customers may well simply not sign up and not use the services of InPost and Yodel over the period, resulting in a loss of that revenue. And if they did, it's very clear that if they did stick with Yodel, Yodel actually wouldn't be able to deliver that service if the reorganisation was stopped in its tracks. So there are two separate points there. If I can deal with them separately, the risk that the customers will simply give up arises in broad terms because they have been in negotiation with Yodel and InPost on the basis that the reorganisation will take place. What they are in principle agreed to take is an InPost Yodel service, integrated. And that's as Mr. Cush has explained. And so there's every reason for thinking that they may well decide, if they're told they're not going to get that they're not actually going to use that service at all and they're going to go elsewhere. Now, specifically in relation to each of them, TVG, the position there, as explained in Crucial 2 footnote 3 at page 134, is that Yodel couldn't actually handle the volumes they had in peak 2024. So if it's been burned once, so it's highly likely to bail out for 2025, I'm told there's no integration. Customer E has said in turn it doesn't want its customers to experience the Yodel brand. That's Crucial 2, paragraph 17.3 at page 135. So if in fact they're going to have to experience the brand because the reorganisation stopped, they are likely to depart. Customer F has said in terms that its volume commitment is dependent on the integration completed. And that's paragraph 18.2 of Crucial 2, page 136. So naturally it's likely to change its mind if told there's not going to be integration. Customer G, it's a new customer, discussions are still tentative, so it's necessarily likely to bail out if told there's no integration. That's Crucial 2, paragraph 19, page 136. And customer H is expressly using September as a trial period before committing to peak volumes. And that's Crucial 2, paragraph 20, page 136. So again, if there's no integration, it's unlikely that it's going to commit to peak. So there's a real danger that these customers will simply go, some of them.
I see from footnote 2 that there was going to be a public announcement towards the end of July 2025. There are 10 hours to go. Has that yet happened?
TVG. No announcement yet, I'm afraid. These things take time. But
No, I just wondered.
so that's the problem here. Now, if they were all to stay in, as I said a moment ago, actually, Yodel wouldn't be able to cope without the reorganisation. This is explained by Mr. McCourt in his second statement of paragraph 17, which is at page 130, because these commitments would produce a need to deliver 6.6 million parcels per week during the peak period. And peak capacity in 2024 was only 5.1 million parcels. So if the integration is stopped now, it's not going to be possible, Mr. McCourt explains, to get to that 6.6 million parcels per week capacity. So if they stick with us, in a way that's great, but they're going to be very disappointed by the end of peak because they will have been let down, because the reorganisation is required in order to actually service what they need. The only way in which we would be able to do it is if in fact some of them left beforehand. So we're going to lose them at one point. Either they stick with us and we can't perform, or they bail out before we get to that point because they see the writing on the wall. That's the risk that's faced. And I've mentioned, Mr. Cushel estimates the revenue loss if they do all depart pre-peak 2025 as 40 to 50 million. I'll refer to that again, that's paragraph 10 at 133. Mr. McCourt then translates that into an EBITDA loss, which he estimates at paragraph 17, at page 130, as to between 36 and 46 million. Again, remembering that this tends to go straight to the bottom line because the overheads are largely fixed. So that's that second category updated. Updating the third category, that's the disaster scenario of collapse and administration. Here, the problem, of course, is that that catastrophic loss of customers would be even more likely to make business unviable. Than perhaps the feared position back in June this year. It would probably undermine customer confidence generally, as Mr. Cushel points out. A second statement, paragraph 22, page 136. And this is something that we have long said. This one goes back to Mr. Cushel's first statement, paragraph 29, page 59 of the core supplementary bundle. He said then that the business could not survive as a business if it has another bad peak.
Sorry, which paragraph again?
Sorry, this is paragraph 29.
29, thank
of
you.
Cushel 1. So even back then,
Yes.
the anticipation was we need to have a good peak 2025. So that's updating the position. So that's really all I've got to say on the question of likely loss. And as I mentioned, the other side of the coin as regards the adequacy of the cross undertaking is the ability of the appellant to actually pay any compensation. And on that, as I mentioned, Moylan Friends not pursuing any criticism, so the judge is finding that their cross undertakings were, and I quote, worthless stands. So the only other thing to deal with on this point about the cross undertaking, my lords, is really the third ground in the notice of appeal, which is this idea that if there was any concern about the cross undertaking's adequacy, it's said by the appellants what the court should have done was to have Yodel apply for an order for fortification and discharge a burden to show that fortification is required. I think I can deal with this fairly quickly. Essentially, the judge was entirely right on this. He held, having decided that the cross undertaking was inadequate, that he would, as a matter of discretion, dismiss the application on that basis, or he would have done if he hadn't already decided to do so on other grounds. And he was quite right on this, and we've referred to authority here. There's the Morning Star case, and then we've referred also to the two textbooks, Bean and G, in the authorities bundle. We might just turn those up very quickly. If you could just look at Bean, it's authority 34 in the second file, 863. And it's paragraph 3-24, and it's really the sideline passage. Very often notes if damages would not adequately compensate the claimant for temporary damage and is in a financial position to give a satisfactory undertakings to damages, and an award of damages pursuant to that undertaking would adequately compensate the defendant in the event of the defendant succeeding at trial, an interim injunction may be granted. And this next bit's the important bit. If the claimant is not in a financial position to honour his undertaking as to damages, and appreciable damage to the defendant is likely, an injunction will usually, but not always, be refused. So we're not saying that the judge had to, having reached the conclusions he did, dismiss the application, but it was clearly well within the scope of his discretion to do so. Indeed, it's the norm. And one gets the same thing from the summary position in G, which is the next tab, tab 35, starting at 865. Bottom of 865, paragraph starts considering the question whether to require or dispense with the requirement of the cross undertakings concerning fairness and having machinery in place, given the court jurisdiction over who's to bear losses caused by the injunction, not enabling the defendant to show the risk of loss. Skipping a sentence, the next sentence, normally an undertaking which can be relied upon to pay damages if ordered will be a requirement if an injunction is to be granted. Even though the applicant is impecunious, the court may, in rare cases, where the merits are strongly in favour of the applicant, in its discretion, still decide to grant the relief sought, accepting that the risk of the undertaking may not be honoured if called upon should not prevent the injunction being granted, or even in exceptional and special cases, dispense with the need to give the cross undertaking at all. So, again, that emphasises the rarity of the case where, if the cross undertaking is of no real value, the court will nevertheless grant an injunction. It can, but it's rare. So the judge's exercise of discretion in this case was entirely normal, standard. Now, therefore, one suspects that this is why the appellants are forced to go off on this argument in relation to fortification, because they're saying, oh no, in that situation, they say the court must grant an injunction unless the respondent has applied for fortification. But that's completely wrong in principle and practice. What it does is it confuses the initial application, the situation where there's an initial application for an injunction on the one hand, and a situation where later, after the injunction's been granted, the respondent comes back and seeks an order for fortification. And so the cases that they refer to, particularly the Mintz case in Malibu, they're dealing with that latter situation, where the respondent is applying for fortification, but the respondent's doing it in circumstances where an injunction has been granted, and the respondent's coming along and saying, well, no, actually, if this injunction is to be continued, there needs to be fortification. But this is, where the injunction is being sought from the start, the position is totally different. It's for the applicant to make out a case for the injunction, and that includes offering an adequate cross undertaking. It might need fortification if the claimant, the applicant's got no assets, but it's not for the respondent to apply for fortification. It's for the applicant to offer it as part of the basis on which the applicant is seeking an injunction. And the court may very well require it in the sense of saying, well, I'm afraid I can't grant an injunction in my discretion without fortification. But it's not for the respondent to make an application for it. And it's not a matter where the burden can be shoved over onto the respondent. In any event, actually, we made it very clear before the hearing that as far as we were concerned, the cross undertaking wasn't adequate without fortification. If I could just invite the court quickly to look at the couple of letters that are relevant. They're in the core supplemental bundle. There's a letter of the 21st of May from my instructing solicitors, page 119. The second page of which is the relevant page. The first page deals with security costs. Over on the second page, 120, there's a heading of fortification. It may be most efficient if I just ask the Lords to read those 3 paragraphs, or 4 paragraphs, 5 to 8.
Yes.
Thank you, my Lords. We've seen from that we made the point that the cross undertaking was worthless without fortification. We identified losses from delay of easily 30 million, and we asked for a proposal for fortification. We did as much as anyone in the respondent's position could be expected to do. And their response is 1 to 2 in the same bundle, 23rd of May. Again, we can ignore the security of the cost bit and go over to the next page. And they simply said on fortification, to the extent necessary, our client will address the issue of fortification in its evidence in reply. So there's no procedural unfairness or difficulty here. We made it clear that our position was fortification was required, because without it their cross-undertaking is worthless, so we didn't do anything about it. And finally, my lords, in any event, even if the criteria that my learned friend referred to in Malibu and Mintz are relevant, which strictly speaking they're not, they're clearly satisfied here in any event, as the judge said. Because what one needs is a good arguable case on three things, according to those cases. First, sufficient level of risk of loss. Well, you've certainly satisfied that. Ample evidence, as I've explained, of very serious levels of loss. Well beyond a good arguable case. Second, good arguable case that such loss would be caused by the injunction. Well, again, we've amply satisfied that because, as I've explained, the mere delay caused by the injunction is the source of the first two heads of loss. And then thirdly, the third criterion identified in the case is the ability to make an intelligent estimate of quantum. Well, we've certainly done that. My lords have seen how we've arrived at our estimates under both the first two heads very clearly. So if we did have to satisfy those criteria, we have, and that's what the judge found, and the judge was right on our respectful submission. So really there's no basis for any challenge to the judge's findings on the adequacy of the cross-undertaking. He was right to find that the cross-undertaking was inadequate, and that was certainly a very strong factor, at the very least, against an injunction. It would usually lead to dismissal. That's what he decided in his discretion, and he was right. And certainly, he was certainly entitled to find that, and there's no basis for questioning the exercise of his discretion on that point.
When he says in paragraph 78, he's satisfied that Yodel does satisfy the criteria relevant to the exercise of the court's discretion. I take it he's referring there to the same cases that have been cited to us.
Yes, Mintz and Malibu, yeah. He was saying for the avoidance of doubt. He was essentially saying just what I've submitted to my lords, that if these criteria are relevant, well, they're satisfied anyway.
So he doesn't spell it out because he's producing the judgment under some urgency, but that's you say what he's referring
But
to.
that's clearly what he's referring to. So that leaves then the challenge on balance of convenience in the notice of appeal. In summary, the judge's exercise of his discretion is in no way flawed, and indeed, if this court were to re-exercise the discretion, it would, in my respectful submission, clearly be compelled to come to the same conclusion. And I emphasise again the point that I made at the start, that it's well established this court should be very slow to interfere with the exercise of discretion on a case of this sort by a judge at first instance. But let me focus on the 3 points in particular taken in the notice of appeal. The first, in paragraph 36 of the appeal skeleton, is really to criticise the judge for rejecting the idea that he was just being asked to preserve the status quo. The position on this is the judge was absolutely right in our submission, respectfully, to recognise the following related features of the case. First, he was faced with a binary choice between two competing forms of reorganisation. Second, there wasn't a viable, sustainable, ordinary course of business or viable status quo. The business needed significant reorganisation. Without it, it was endemically loss-making and unsustainable. And all that was common ground. It was common ground that Yodel required continual financial support during that process, the process of urgent transformation. And it was also common ground that that transformation would involve integration with another business. The judge records that as common ground quite rightly in paragraph 6 of his judgment. And it's interesting that Mr. Corlett accepted in his evidence, and this is Corlett 2, paragraph 75, which is page 80 of the Court Supplemental Bundle, that his proposed merger was, and I quote, not wholly dissimilar to the one being pursued by Yodel currently. That just reflects the fact it's common ground that the business of Yodel is not sustainable on a standalone basis. It has to be integrated with another business in order to make it viable. And thirdly, and importantly, there isn't any middle way here. Judge was right to recognise that. It's not possible to restrain a bit of what is being pursued by Yodel at the moment. It's an all-in process, one way or the other.
Of course, Mr. Rivet was rather sort of taking issue with that. He was suggesting that bits of the injunction could stand on their own.
Yes, he described bits as being benign, but it's absolutely plain, and it's been plain. To be fair to the appellants, they put it this way from the start. They want to preserve the business in its pre-reorganisation form, so that they can reorganise it. That's the whole purpose of the injunction. So, and I'll show you some evidence of Mr. Fisher, who's the director of Shift, about this. But so that's been their position from the start, that they want to preserve the business so they can reorganise it in their way. They want to preserve it intact, as Mr. Fisher put it, as I'll show you in a moment. And equally, from our point of view, this transformation process, which I've shown the Lords, it's an all-in process. You can't cherry-pick bits. It's got to be done properly, or not at all. As you've seen, it requires an enormous amount of investment. It will, we believe, produce very significant benefits. But you can't have a little bit of it and not the whole thing. It's all in, or not at all. It's hardly surprising, really, if you're going to integrate a loss-making business with another business to create something that is profitable. Of course, you've got to do it properly. You can't nibble away at the edges. So it's entirely wrong, and indeed it's rather contrary to the position they were taking at first instance, to suggest that somehow one could have some of the injunctive relief but not the whole lot. And for a start, if some of it were ordered, that would put an end to the reorganisation process, because if we can't do it properly, we can't do it at all. So it's a binary decision, basically, who to carry out the reorganisation process. And to the extent the judge was choosing between the two, he was absolutely right in his choice, because you have the Yodel process, which is clearly carefully formulated and budgeted, as you've seen. It involves integration with the in-post business, which is successful, backed up by a very large group. And it's already underway. It was already underway back in June, and it's more than underway now. And in-post had already by June committed a 9-figure sum to that process. And that was obviously far superior to what was on offer from the appellants back in June, which was a reorganisation and integration with Shift, described as not wholly dissimilar, but without any plan put in evidence at all. And in particular, as the judge rightly placed, on which the judge rightly placed great weight, no plan as to how it could be funded. And this idea of a Shift reorganisation would require funding quite plainly in two respects. There's payment off of the, well, then 168 million, now 198 million, and more than that, that would have to be repaid to JLL. And that's before you even get to the costs of the process. As you've seen from looking at the 2+10 document, you've got capital costs and you've got exceptional costs. And the 2+10 document estimated the exceptional costs alone being 25 million. So this process, this not wholly dissimilar process that Shift wants to engage in, would clearly involve a lot of cost in just doing it. So they've got to deal with they'd have to explain how they were going to pay off JLL to get to the starting gate, and then how they would actually fund the process itself. And as it was accepted, as the judge recorded, It was accepted by the appellant at first instance that yes, they would have to find a way of paying off the JLL debt, and no, there wasn't any evidence as to how they could do it. And that's recorded in the judgment. I'll give you a reference in a moment. Actually, on the evidence, the appellant's plan isn't remotely feasible, because unless there's evidence as to how they're going to repay that JLL debt, it's not feasible. And that's actually fatal to the application, my lords, because the whole point of the application, the only point of the application, is supposedly to preserve the Yodel business so that that reorganisation can be pursued. If in fact it's not feasible, or there's no evidence that it's feasible, there is no evidence that this injunction would have any purpose. And most certainly, if one had to choose between the two, quite clearly the reorganisation that's currently in progress has a far better prospect of achieving success than the reorganisation which doesn't even have a plan that's floated by the appellants. And it is, of course, notable in this context. Mr. Corlett had one go at achieving this shift Yodel merger in the first half of 2024 and failed. And it's actually really striking that it then took 6 months when nothing happened. The appellant's story is that they had these warrants in the bag on the 21st of June. As you know, we don't accept that. But if it were the case, then there's no decent explanation as to why it took them 6 months to then exercise them, if the whole point of exercising them was, as they now say, to pursue their own reorganisation.
Just help me. There were 2 batches of warrants.
Yes.
We're concerned with the second batch.
Yes.
Were all those warrants exercised?
No. There are some not yet, but the shift of the Corja warrants would give more than 50% of the shares by number, so they're enough to allow them to mount this argument that they do in support of the injunction. The point I'm making now is that if they were dead keen to pursue a merger between Yodel and Shift, then they should have been exercising them straight away. In June, July 2024. Now, Mr. Corlett puts forward an explanation. He says, this is Corlett 2, paragraph 122, 2427 of the supplemental bundle. I'm sorry, I haven't got the reference to the core supplemental bundle.
What paragraph numbers?
It's 122, paragraph 122. He says, well, he thought that the warrants couldn't be exercised until JLL sold Yodel. So in other words, he thought that the 21st of June 2024 transaction didn't allow them to be exercised. He says he didn't get legal advice to show the true position until late in the day. And that's very unconvincing. He drafted these things, albeit based on his pre-existing lawyer-drafted document. It's clearly not what they say. And if he'd have been keen to actually achieve this merger that he's so keen to achieve now, he says, back then, he'd have rushed off and taken advice as soon as possible. So it really doesn't stack up. Now, the laws obviously can't make any findings about this, but I mention it because it explains why we actually believe this is all just an attempt to exert pressure on us.
Sorry, just so I get a clear note, where do I find that explanation?
That's Corlett 2,
It's
paragraph
Corlett
122.
That's page 83 of the course.
Nice, thank you.
Thank you, Lord, I'm most grateful. So if you add all these things together, no plan, massive delay, no decent explanation for delay, failure back in the first half of 2024, there really is nothing to recommend this supposed proposal for a shift Yodel merger at all. Certainly by contrast with the current reorganisation. So that's the first point. Second one, that the appellants raise. They say that the judge was wrong to think that this was going beyond preserving the status quo because it effectively transferred control of Yodel to the appellants. And clearly, it would have been the effect of the injunction because the order expressed, leave aside ordinary course of business, the order that they were seeking and still seek expressly prohibits Yodel borrowing money over £50,000. Yodel well, certainly back in June this year, Yodel needed more than £1 million a week to borrow to cover its loss making. So it was clearly going to need the consent of the appellants if it was actually going to continue at all. And if an injunction were granted, the plug could be pulled on Yodel by the appellants at any point over the 6-month period. And of course, the appellants owe no fiduciary duties at all. They actually have no status within the company whatsoever. And yet they would effectively have more control over the question of whether to continue the business of the company than the directors, who of course owe fiduciary duties. And that's a particularly startling outcome in our submission in circumstances where the company is insolvent. And so the directors owing their fiduciary duties, including the creditor duty, will naturally be especially acute to consider creditors' interests while they consider whether they can carry on with the company's trading. The appellants, on the other hand, would owe no duties whatsoever. They could act entirely selfishly. It would be a remarkable outcome, and it certainly wouldn't be preserving the status quo. And the appellants even suggested that the judge failed to take into account the possibility that Yodel could seek their consent. Well, he clearly did take that into account. One can see that he did that in his reasoning in paragraph 80 of his judgment on balance of convenience. He just didn't think it was an answer, and he was right in thinking it wasn't an answer. Then the third point the appellants make on this is paragraph 39 of their appeal skeleton. They say the judge was wrong to take into account the issue of whether the appellants had evidenced any plan for repaying the debt to JLL. So they accepted, as I mentioned, and this is paragraph 68 of the judgment where this is recorded. So this is core bundle, page 149. They accepted, as the judge recorded, that it would have to be repaid. And they accepted there wasn't any evidence as to how they were going to do it. So they're now forced to argue that the court just shouldn't be concerned with that, because it shouldn't be concerned, they argue, with how the appellants propose to manage the business if they win. But this misses the point, because they've clearly got to pay the debt. If they can't do it, there's no prospect of a shift merger, as I submitted a moment ago. So the whole purpose of the injunction goes away. So they can't dodge the point. It goes right to the heart of whether there's any purpose in granting an injunction at all, leaving aside everything else. If they haven't shown that there's a real prospect of actually being able to pursue this reorganisation, this merger, there is no point in an injunction, even if, in all other respects, it had the best merits possible. Because that's the only point of doing it. And I also add here, it's unjust really to expect JLL and Impost to continue to fund the business and the losses for the duration of any injunction, in the sum of over £1 million a week, as it was in June. Clearly with no expectation of any repayment and no prospect of any compensation under a cross undertaking, because it's worthless. Indeed, it's just unrealistic to expect or assume that to take place.
Well, that does depend on your assessment of the prospects, doesn't it? I mean, if you're confident of your case, then you're putting in the money, but that makes sense because you know you're going to win.
There's a premise for the injunction. It's an applicant to say, right, the premise of our injunction is we're going to just assume that the other side are going to put in £1 million a week for 6 months. That's pretty outrageous. I mean, standing back, what they're asking for, what they were asking for, what they're still asking for, is utterly unjust and unreasonable. They want to enable them, in theory, to pursue a proposed reorganisation for which they haven't got a plan. They want Yodel preserved in this loss-making, standalone situation, even though it's not viable. And they want us, the other side, to find the cash, £1 million a week for 6 months, without any prospect of getting it back, and without any prospect of compensation from them if the injunction is wrongly granted. And they're not offering to put in a penny. It's pretty startling stuff, in my submission. And so we on this side are expected to find the cash, take all the risk, just so they can potentially, if they happen to be right at trial, pursue a plan for which they haven't provided any evidence. It's just patently unjust and unrealistic. Now, although that deals with the 3 points they've made, there are just a short number of further points I want to make on balance of convenience, because they're points we've relied upon below. I'll make them very briefly, because they are relevant. And it may well be the judge did actually take them into account. There are points we made, but as you see, the judge's reasoning was extremely brief, understandably. Number one, there is the wider harm potentially caused by the injunction. So leave aside the specific compensation, uncompensated loss. The employees and the contractors and the creditors' losses, and I mentioned again in particular the fact that the creditors are the primary stakeholders in this position. So it's not just the huge uncompensated losses for Yodel. Second, the merits. It's perfectly proper, even under cyanamide principles, to take account of the merits, not conducting a mini trial, but if it's clear that they are more likely one way than the other, because in our submission it's highly likely that this claim will fail. And it's therefore likely that all this uncompensated loss that the appellants are asking us to bear will be borne for no purpose. Thirdly, the appellant's loss is unlikely in any event. First, because it's unlikely they're going to win. But second, because as I submitted on the question of the adequacy of damages for the appellants, even if they do, and even without the guarantee that we're offering, it's unlikely that the loss will be significant. So if one balances up the potentially uncompensatable loss on either side, even if one thinks that there is potentially uncompensatable loss for the appellants, it's quite clear the balance is vastly in our favour. Fourthly, if an injunction is wrongly granted, the uncompensatable loss that we would suffer is inevitable to some extent, particularly that 33 million if one goes back to June, or 18 million if one looks at the position from today. Fifthly, the risk of harm has been enhanced by the appellant's use of heavy publicity in the press. We haven't had to look at that evidence, but just from my Lord's note, we made this point in our evidence in support, and that's Taylor 1, paragraphs 39 to 42, McCourt 1, paragraph 45.
Sorry, I'm not keeping up. Taylor 1,
Sorry,
paragraph.
apologies. Taylor 1, 39 to 42.
Yeah.
McCourt 1, 45. Cushel 1, 37. And Mr. Corlett responded in Corlett 2, at paragraph 109, where he accepted that he had spoken to the press. No doubt he would say, oh, everything I said was entirely fair. But in a high-profile case like this, you only use the press for one reason, and that's to try and put a bit of pressure on the other side. And we, of course, as we made clear in that evidence, didn't regard what he said to the press as fair at all. But the point is, it makes it worse. And it's not, if you're somebody who wants to take over a company, preserve it, and then reorganise it, you don't go to the press to try and make life more difficult. It's not helpful. And finally, my own friend introduced an additional point. He said, well, when Impost went into this, as he put it, eyes wide open. Well, in relation to that, I'd say the following. What he's getting at is he said, oh, well, when Impost acquired its controlling indirect stake in Yodel in April this year, it knew there was a warrant claim. True, yes. But before it knew of any warrant claim, that is, during the course of 2024, it had already advanced multiple millions by way of loan, under convertible loan notes, indirectly through JLL to the company. So it was already halfway in. In any event, that doesn't entitle the appellants to an injunction. What it does do, as my Lord Justice Newey pointed out in argument with my learned friend, it certainly demonstrates that any of the losses that we're referring to now as potentially flowing from the injunction certainly don't flow simply from the existence of the claim. But that's its only relevance. Now, I should briefly, I will do it briefly, just address my lords on the balance of convenience position as of today, by reference to the new evidence, in case that's ever of relevance. Really, what that evidence shows in our submission is that the reorganisation has proceeded at pace, and that's had two results in our submission. First, the steps taken are largely irreversible, unsurprisingly. That was, of course, always what the appellant said at first instance they feared would happen. Second, an injunction now, as you've seen, would prevent Yodel and Impost from meeting commitments made to customers, particularly in relation to peak 2025. So it would seriously undermine the business. So those two factors actually weigh even more heavily against granting an injunction now. Because many of the events that the appellant sought to restrain have now happened. The reorganisation isn't complete, but it's proceeded a long way down the road in a way that's irreversible. So really the shift, assuming the shift merger were practical anyway, it's become impractical now. And I mentioned Mr. Fishley in his second statement, paragraph 25. I don't think this is in the court supplemental bundle. It's at page 2559 of the supplemental bundle.
Sorry, which volume is that again?
It's in. It's the last. File 5.
Right.
It's 2559. Mr. Fishley, of course, is the director of Shift. What he
2559.
Yeah, and it's paragraph 25. And he's dealing here, he says he's aware that some of these steps, that is the steps they're trying to...
Actually, it is in the core bundle. It's
Oh, I'm sorry.
Page 91.
Sorry, thank you very much. Apologise. So he's here talking about the shift plan. And if you pick up the fourth line, these plans, two plans, have some similarity to those outlined by Mr. McCourt. Both sets of plans include some rationalisation of the depot estate, both with initiative to improve last mile delivery costs. Some initiatives could be implemented regardless of ownership. The approach to others would depend on whether integration is with Shift or within Post. And then the final sentence is important. The Shift plan was developed with input from both Shift and Yodel. My belief is that it remains viable. This is the crucial words, but only if the start point is an intact Yodel. So this is Mr. Fishley back in June, or late May, for the June hearing, making a point in support of their submission that they needed a complete block on any continuation of the Yodel reorganisation. Making the point, he says, that the Shift plan would only be viable if the start point is an intact Yodel. And what he means clearly there is a Yodel that's not been integrated within Post. So if that's right, what he said then we've certainly got to a point now, by the end of July, where there has been substantial integration between Yodel and InPost. Of course there has, that's what was always in the plan. And so on this ground as well, now, it would seem that the Shift plan is no longer viable anyway, to the extent it ever was. But further, as I've mentioned, the downside of injunction is now, as the evidence in Cushel 2 and the Court 2 shows, even greater. Because they have gone further down that road of committing to customers, and so the prospect of the reorganisation now being brought to a juddering halt creates even greater risk the business will collapse, because they will have a disastrous 2025 peak. They will lose customers, and the business is simply at risk of becoming no longer viable if that happens. So the case against an injunction was overwhelming in June. It's even stronger now in our submission. That's basically what I had to say. When I made a couple of comments about the terms of the order, if I may just reserve any submissions on that. I'll just make the general point that a general restraint on acting other than in the ordinary course of business is far too vague for an injunction. Second, if there is to be any order, it certainly shouldn't restrain the appointment of administrators. That's what the directors feel they have to do. And then there is that point about JLL having the benefit of a cross undertaking. I set out the reasons for that in paragraph 62 of the skeleton. I'll say no more about it now. So unless I can assist you further, there's submissions on the appeal.
No, thank you very much. Yes.
Maybe not. Sorry, I've dealt with it.
Okay.
My own friend. Thank you, Lord.
Thank you very much. Yes, Mr. Rivet.
Actually, just before you sit down, I'm sorry. At some point, you'll send through the revised guarantee.
Oh, yes. Oh, we got it. Oh, I think.
Red line as well.
Sorry, we didn't have it at 2. It looks like we do. We got it.
I haven't got it.
Oh, right. Sorry.
Thank you very much. That's right.
Thank you. Right, I see.
So what it's intended to do is just change the identity of the guarantor.
Yep.
So therefore, recital D has become obviously otherwise it's in the same form, I believe.
Except you've taken on board what Justice Mayall's point in
You
paragraph
have.
24.
24, yes, we have just seen that we have, yes. So I hope that would, if required, provide a complete answer.
Thank you very much. Yes, Mr. Rivet.
Yes, thank you, my lord. I'm going to start with the first ground of appeal, which was the adequacy of damages, which I hope we can deal with fairly briefly. It was said by my learned friend that I had strayed outside of our grounds of appeal by addressing you on what our loss was. That, in my submission, was not fair criticism for 2 reasons. The first was, as I said at the outset of my submissions, was that I was addressing the question of loss because it was a point raised by the respondent's notice. They were coming back and saying, well, the judge's decision to be upheld on the additional reason that we haven't actually shown any loss. And so obviously I necessarily needed to address that. And the second point is this, which is the production at the 12th hour of a guarantee from InPost's parent company, which is now said to be a complete answer to this point. But if the court is going to take that into account, it must necessarily have regard to what our loss is. And as I said this morning, our loss is hard, if not impossible, to quantify. Our underlying claim is a claim for specific performance. Now, it's not an answer for my learned friend to say that, well, if we succeed, we will get that remedy, we'll get the shares in the company to which we are entitled. But as I said this morning, that's not quite what we want. It's not a question of having particular shares in the corporate vehicle. It's the business. It's shares in the business. And that business is being changed dramatically and irreversibly. And clearly we have plans for the business. If we didn't, we're not here on a point of principle. We obviously expended a lot of resources and time in this litigation because we feel that if we do get hold of the business, we can make a success of it with our own plans. And that is something which we will be denied if the transformation plan is allowed to proceed to its conclusion. And turning then to the second ground of appeal, which is the cross-undertaking and damages. Now, my learned friend, the first point he said towards the end of this morning's session and this afternoon is that there is an inevitable trading loss of 30 million, which I think he now reduces to 18 million, caused by delay, as I understand it. And he says the court doesn't even need to take into account the transformation plan, because that is a loss which will happen anyway. But that is a loss which has nothing to do with the injunction. It can't be pinned on the injunction. It was a pre-existing trading loss, the one going forward. The only way in which it could be blamed on the injunction would be if somehow, but for the injunction, that loss would disappear. And to demonstrate that, as I said this morning, he needs to explain how his transformation plan would work. It would reduce the losses. I took your lordships to the 2+10 document, and my learned friend took you to it as well. And that showed you the estimates which had been forecast as part of that plan, upon which its success depends. And the fact is that as of today, those estimates have not been achieved. And we're told, over my learned friend on his feet, that the reason why they haven't been achieved is because of the delay while the undertakings pending the applications being heard below was in place. They say, well, it was just a delay. The reason why there's a lag time is because there was a delay in that. But that's not what Mr. McCourt says. Paragraph 16 of his second witness statement at page 129.
Yes.
In the last sentence, as well, Yodel has progressed the integration since the 11th of June, and this has helped to reduce that burn rate. In July 2025, we estimate the EBITDA loss will be 3.3 million. It remains significantly loss-making. We will not be able to do anything about this if the integration is now paused. And what he doesn't say is, well, the reason why in July we were still loss-making is because we're behind with our transformation plan. Nor, for that matter, does he set out any revised figures. They were able to do that in the draft document, which we've looked at, what their projected figures were going forward. So why can't Mr. McCourt do that now? If in fact it is his evidence, the reason why they're still suffering losses is just simply because of the delay in its commencement. In fact, what he says is it remains significantly loss-making. So on that basis, the plan isn't working. Now that was the first of his examples of losses, which was the ongoing trading losses. He then addressed your lordships on customers. Says, well, this is a serious risk of customers. Now, my submission, it was quite hard to disentangle Yodel's position from that of InPost in his submissions. And a good example of that was with the Very Group, which I took your lordships to the evidence on this morning. My learned friend has referred to again this afternoon. Now, if we're looking at the perspective of purely Yodel, that is a customer which has been lost. And it's been lost not because of anything which Yodel itself, well, it is of course what Yodel has done because it was done in the inflation of its directors. But that is something which has been done not as a consequence of any injunction, the effect of the injunction. It's been done because of the implementation of the transformation plan. Mr. Kushner is quite candid about that. It was based on discussions. He has redirected the contract to InPost. And even on the basis of that evidence, as your lordships will recall, it shows that the terms, purely on the basis of the number of parcels which are being delivered, are inferior to those which Yodel had before. Now, entirely accept, he may well say, well, from the perspective of InPost, this is a much better situation. This transformation plan is great. But we're not concerned with InPost, we're concerned with Yodel. Now, with the exception of the Very Group, we're in fact given very little information about the other customers. Mr. Kushner refers to conversations with them. We have no evidence, supporting evidence to support those discussions. We're just told that that's what he's had. That's what they've said to him. No way of testing that. The only really concrete example we've got, as I say, is in respect of the Very Group. And that, far from presenting a positive picture for Yodel, presents a very negative one. The next point he said, talked about, was the question of administration. Now this sort of ties in with the question about InPost funding Yodel during the period while the injunction is in place. And my learned friend saying, well, that's all terribly unfair and unjust, that they should be expected to put their hands in the pockets and we sit back. To which, of course, I have two answers to those. I appreciate I'm repeating myself, but it is important the court has the chronology in mind as to how we got to this situation, how InPost has got to this situation. The first point is that InPost's loans, my learned friend started in 2024. During the course of that year, up until the end of the year, I think it was 25 million they loaned. Now, they may have been in the form of convertible loan notes, but at that stage, InPost was not the parent company of Yodel. As is common ground, by December and certainly by January, InPost were aware of the warrants because they were exercised. They continued to loan money. In fact, the amount which has been lent has been substantially greater than that since then. Of the 200 million, which I think is said has been loaned today, 175 million of that has been loaned since January, since they knew about the warrants. And it was only in April, 4 months later, that InPost actually then converted its loan notes into shares in Judge Logistics and took control. So the idea that somehow we're just sitting back and expecting them to fund this during that process ignores the actual background to it all, which is that InPost has been apparently perfectly content to carry on funding this business, notwithstanding the existence of the dispute. And in any event, as I said again this morning, we have never said, maybe I misrepresented my learned friend said, but we've never insisted that InPost has to provide this funding. That's its choice, just as much as it's its choice to withdraw it. When Mr. Corlett was in control of the company, he found other funding sources. There's no reason to think there wouldn't be others available today. It suggests that this is entirely dependent upon in-post goodwill. Is my submission wrong? Now, we then turned to the question of fortification and said, well, it was enough just simply to show that the cross undertaking is inadequate, is insufficient. That's all that needs to be shown. But to that, the question is, well, how does one show that the cross undertaking is insufficient? And that was really my point this morning. What is the test which the court applies when assessing whether the cross undertaking is insufficient? And that test, I would submit, is the same as that which applies when the court is assessing whether or not to order fortification. And that's partly because, as I said, it's from the authorities, and you may recall the passage from the DPR Features case of Mr. Justice Millett. From there, the court, and indeed from Mr. Justice Mann's approach in the Sinclair case together, which is the two issues are fairly inseparable. They're two sides of the same coin. Because as a matter of reality, commercial reality, if a defendant is submitting that the cross undertaking is inadequate, it almost follows, as it did in this case, that they will also be applying for fortification.
When you say apply, did they apply? They said,
Well,
we don't think it's good enough, but did they make an application?
There was no formal application notice, no, but it was raised in their evidence and in their submissions. And your lordship has seen the correspondence in which it was also raised. It was quite clear that they wanted fortification.
Yeah.
My learned friend then said, well, the cases which I took your lordships to, the Malibu case and also the National Bank Trust case, they don't apply at this stage. That's when someone comes along later and says, well, we want fortification. I'm afraid, to follow why that would be the case. Why is it any different whether you're applying from the off to then applying at a later date? In both instances, the issues are going to be exactly the same. You've still got to establish, well, what is the risk of loss? Is it caused by the injunction? And can you put an intelligent estimate of what that loss is? Those same questions arise at whatever stage. Now, I can see if you have an ex parte injunction, the position might be different. Because, of course, the ex parte position, well, it's different only because one of the parties isn't there, and because of the duty of full and frank disclosure, the applicant is basically supposed to be speaking for both. So at that stage, I can see that the applicant's burden would be to also address the question of fortification, and if the court considers it has concerns, and to volunteer it at that stage. But we never had an ex parte injunction in this case. It always went to an inter partes hearing. There was always, the respondent was always here to make out its case on that point. And in my submission with the reasons I gave this morning, I submit that the criteria were not satisfied, still not satisfied. Turning then to the balance of convenience, my own friend said, well, the judge was faced with a binary choice between two competing visions for the company. Essentially, the question for him, was on which vision should be allowed to proceed. But in my submission, that's the wrong question. That wasn't the question for the judge. That's a commercial question. The question for the court is a straightforward legal one. who is entitled to be in control of this company? And it's for the person in control of the company, the person who owns it, it's for them to decide which vision of the company they prefer, not the court. And that really is the purpose of the injunction, which is to allow the appellants to have a proper opportunity, not to have it imposed upon them by the respondent. It's to find themselves, to use my Lord Justice Newey's description, in a mess.
Technical term.
Technical, exactly. There's nothing unjust or inconvenient about that. Certainly when my learned friend was addressing you on the legal principles, suggested that, well, he accepts the court would have jurisdiction to make an order along the lines we seek. He suggested it was an exceptional one or an extraordinary one because we were seeking to restrain perfectly lawful activity. But I think Lord Justice Mayall's made the point, that's ignoring the context. The context is we say they shouldn't be in charge of this company at all at the moment. And it can't be the case, and every time a company is injuncted from doing something, that the proper interpretation of that injunction is somehow that the board is being overridden by the court. Now, my learned friend relied on some further points in support of his case of balance of convenience, which weren't relied upon by the judge. And the first is he referred to the wider harm caused by the injunction. He referred to, amongst others, employees and contractors and creditors. In my view, that was a rather rich statement to make in circumstances where they are making employees redundant. It's referred to in the second witness statement of Mr. Cushel. Sorry, it's not. In fact, it's the second statement of Mr. McCourt. That's the tab 9 of the core supplementary bundle, page 127, paragraph 12.2.
Yes.
He then talked about the merits of the case. But he says, well, this is a weak case. Well, that obviously wasn't the view of the deputy judge. And in fact, a second High Court judge has reached the view on another separate application that this case easily meets the threshold of a good arguable case.
Good arguable case or serious question to be tried?
Well, I think the modern jurisprudence is that they're the same in the case of an injunction. If I show your lordship, just to, if there's any doubt over that, it's referred to in the judgment below. In fact, it's paragraph 50 of his judgment. Where on page 144, where the judge refers to the test, refers to the Yodel and Dos Santos case. He actually does, I'm afraid, contrary to what I thought, still refers to the terms as seriously should be tried.
Yes, I think good arguable case means different things according to what kind of context.
It is, and I'm
position, but
exactly.
You're saying here they mean the same as serious question.
Exactly. My understanding, I'll be correct. Well, if it's seriously to be tried, I'll use that language instead. But my recollection of the case now is that in the context of American Cyanamide, it's the same question. It's deemed to be the same test as.
Yes, I think you might be right. I think jurisdiction is where it's a higher test.
Yes, exactly. That's the difference. He then, my learned friend's other point was he said no loss. Will you have my submissions on that? Likewise, you have my submissions on his next point, which was if an injunction is wrongly granted, loss is inevitable, which is a point I don't accept. And then bringing the matters up to date on the balance of convenience, he says, well, the transformation plan is now a long way down the road. The shift merger is completely impractical now. But I'm not sure it really lies in his mouth to say that. It's for my clients to express a view as to whether or not this relief is still worth, anything in this relief is still worth pursuing. And clearly they have the view that it is worth pursuing, because that's why we're here. And the obvious aspects of the business, which even on the basis of the evidence which we've seen, which are still there but may not be in a month, would be things like the brand. The Yodel brand is still there, but is clearly being moved out. Phased out, I should say. And in terms of the relief which we seek, just to remind your lordships, it's at page 15 of the core supplementary bundle.
Did you say page 15 of the core supplemental?
It's,
It is,
but
yes.
it's also as set out in paragraph 36 of the judgment.
Well, yes, in fact, if the judgment is open, we can,
That's what we mean.
yes, we'll do it from there. Sorry.
Looking at it.
Yes, in that case, it's page 140 of the core bundle,
Yes.
and tab 9. Now, I had discussed obviously at length, certainly subparagraph A this morning, but I also remind your lordships of subparagraphs E to H.
Yes.
Now, those are clearly ongoing. Well, and we don't know about transferring of shares, but certainly we know about the novation of contracts, and the rebranding hasn't yet happened. We know, we've seen in the case of the Very Group that sounds like in the case of one customer at least, the ship has already sailed, but they are transferring customers. Now, it's not clear why these aspects, if stopped now, there is still an independent business. It's still got its customers, it's still got its brand. It certainly isn't clear on the face of the evidence to me that they presented as to why those matters can't be at least be paused until the outcome of the warrant claim. They say that in-post involvement is so crucial to customers. Well, we're not stopping in-post from still being the parent company. It will still be the parent company in this business until the warrants claim is decided. It will still be there. Customers can still see that from Companies House if there's any doubt over it. What we are stopping, not stopping, but certainly invite the court to pause, is some of these elements solely for 3 months until the warrants claim could be decided. And specifically those points in E to H. Excuse me, I'm just using instruction. Unless I can assist your lordships further.
No, thank you very much. We'll rise now for a few minutes.
Court rise if able to.
Can you tell us how long it would be? 2 months. It's going to get groomed before your vote. Yes, well, it should be great if we get some hair. Not the full page of I share mine.
Cauterize if able to.
Yes, thank you very much for your respective submissions. We do not need to hear submissions on the respondent's notice. The appeal will be dismissed on the basis that the guarantee which has been proffered will be put into effect. Our reasons will follow in due course in a draft judgment which will be sent to you for the usual limited purposes. And we would hope that once you've received the draft judgments, you will be able to agree an order, but if not, we will deal with any outstanding matters on paper.
Great for me. Thank you very much.
As I say, thank you all very much for your comprehensive submissions, which dealt with all the points that could have been made. So thank you very much.
Cauterize if able to.